Hello everyone, it's Mark and welcome back. In this video, I want to talk to you about the Baker Act and the State Attorney's Office. So what does the State Attorney's Office, which is an office, an agent of the state that prosecutes crimes, what does the State Attorney's Office have to do with the Baker Act? And that's a great question. It really is. And as a former assistant state attorney and a proud former assistant state attorney from here in Palm Beach County, I'm actually pleased the question was asked. It's a really great question. So let's talk about that. So as I've said in other videos, there's two ways that you can be detained at a Baker Act facility: voluntarily and involuntarily. Now, if you're voluntary, what does that mean? It means that you've agreed to stay. And people say to me, well, Mark, why would anybody agree to stay? Well, sometimes people agree to stay because they get tricked into staying. They sign a document which says consent to treatment, or the facility says, listen, if you don't sign this document, guess what? You're never going home. Or if you don't sign this document, we're going to go to the judge and the judge is going to give us a court order and you're never going to get out of here. And so that's how sometimes somebody can be voluntary, right? Or sometimes people have go to the hospital and they're just looking for some help, and the hospital says, well, look, if you'll agree to treatment, we'll have a psychiatrist come down here and, quote, check you out, right? So that's voluntary. If somebody is involuntary, meaning they're being detained against their will, and there's a number of ways you could become involuntary, then the facility can legally hold you if you meet criteria, and that's a big if you meet Baker Act criteria, you can legally be held for up to, not for, but up to 72 hours. So it's not a windfall for the facility, although more often than not it's treated as such, right? You can be held up to 72 hours. Now, once 72 hours expires, right, one of two things are supposed to happen. And I say supposed to because the problem with the Baker Act is that there's no oversight, meaning nobody is watching these facilities and making sure they do things correctly. But let's presume, for the sake of this video, that they actually do it right. At the end of 72 hours, one of two things must happen. Either one, you should be released, or two, the facility has to file a petition for involuntary placement. And actually, I'm going to give you one other little scenario that's not often talked about, but in theory, the facility can ask you to go voluntary, okay? And I'm trying not to confuse you. So for sake of this video, there's two options, right? Either they let you go, or they file a petition for involuntary placement. Once that petition is filed, a placement hearing must take place within 5 days. So if the facility just wants to keep you another 4 or 5 days and comply with the statute, even if they have no intention of going forward with the hearing, they automatically get another 4 or 5 days. And then a hearing takes place. And what does that hearing look like? Well, that's when the state attorney's office steps in, because don't forget, the Baker Act is a statute that authorizes the state of Florida to take custody of you, not when you've committed a crime or you've done something wrong, but when you're alleged to be suffering from some type of mental illness which results in you presenting as a danger to yourself and or somebody else. In other words, you're suicidal, potentially suicidal, allegedly suicidal, and all of that good stuff. Okay, but at that hearing, which is going to be prosecuted by the state attorney's office, okay, there's also going to be a judge, and there's also going to be a defense lawyer. Now, typically the public defender is automatically appointed by the court. If you want private counsel, of course you can hire a private lawyer. We do these hearings every once in a while when we're required to be there. But this case is treated as if it was a criminal case. Prosecutor, defense lawyer, judge. Okay, the only difference between the Baker Act hearing and a criminal case is in a criminal case, right, it's open to the public with very small exceptions. And I can tell you that as a young law student back in the 90s, early 90s, I used to go watch a lot of court because I wanted to try cases. And, I think Friday was the day I had no class, and I'd spend all day just watching trials. It was really fascinating stuff. Okay, which is why if you go on Court TV, you can watch most of these trials, right? That's why OJ was public, right? That's why this Amber Heard Johnny Depp case is public, right? Because there's a general rule, those cases are, those court proceedings are open to the public. But the Baker Act proceedings, where you haven't done anything wrong, you're not a criminal, they're not open to the public. In fact, they're done in secrecy under the guise that they're confidential, which means that if you're the member of the general public, you don't get to go and see if these things are done right. And here's the state prosecuting you. You haven't done anything wrong. And that's how this whole thing works. And so, yes, the state attorney's office gets involved. And I'm going to give you one other caveat. As a general rule, the state attorney's office does not get involved unless the facility files a petition for involuntary placement. But there are a couple of counties that as soon as I file my petition to get somebody out, the state attorney's office wants to be involved. They want to know what's going on. And actually, I think that's a good thing, because it at least means that the state attorney's office is making sure that the facility, who's also an agent of the state, is doing things correctly. And so I'm grateful for those state attorney's office that do get involved at that early of the case. In any event, that's the involvement of the state attorney's office in these Baker Act cases. And with that said, I'll see you in the next video. Bye-bye.